Okay, let's go ahead and get started. Sorry, we are just running a moment, 2 minutes late. We had some technical difficulties on my end. Welcome to Effective Annual Meetings for 2023. My name is Colby Shear. I am the Director of Operations for Ardent Residential. And with me tonight is Atlanta's own super lawyer, George Nowack. Sorry, you're like a superstar. Just own it.
Well, that's so nice of you to say. I appreciate that.
Well, it's so true. You helped write a lot of the laws
I
that are
did.
on the books. So
Yeah,
kind of an expert.
all I've ever I always say it this way. I've practiced law for 42 years, and all I've ever done is practice community association law. I got in on it when there were only two law firms in the nation that said they did it, and I'm one of the handful of people who've stayed with it. And I love what I do. Every day is different because the law itself is only 50 years old. And if you think about law, they're hundreds, thousands of years old. And here's this area, sort of like environmental law, that's new law. So I
Right.
appreciate it. Yeah, I've had a lot of fun with it.
Yeah. Well, it's always fun to get your insight on things and learn from you because I do know we've worked together, I think we were talking
Sure.
about 20 years ago on a very special
Sure.
community. And but it's always a pleasure to work
Thank
with
you.
you or just talk with you in any capacity.
Thanks.
Uh, yeah, thank you.
You're welcome.
So let's dive right in. So let's start with what is the basis for an annual meeting? And well, that answer is pretty easy. Your bylaws, your corporate bylaws, right?
Hmm?
And the Georgia Nonprofit Code. We're
Yeah,
going to get into all that.
correct. Yes.
But
Annual, annual meetings are required to be held annually.
right.
Yes.
Yes, that's something that's discussed. And just for the purposes of this webinar, we are only talking about annual meetings. There are many other types of meetings held by associations and mandated by your association governing documents, your board meetings, special meetings, anything else. But
Sure.
this is specific to annual meetings because it is annual meeting season for a large percentage of communities in this area, well, and around the country. When we do talk law, please keep in mind that we are talking about Georgia specifically when it comes to the law. Documents generally as they relate to associations, and we are not actually providing any specific advice to a specific situation. If you have a situation in your community, and I'm sure we'll cover this again somewhere, but please reach out to your manager and to your association attorney so that they can review all of the relevant documents and give you association specific advice. So
Mhm. Well
back
said.
to, thank you. So when we are thinking about scheduling our meeting, what relevant governing documents do we need
Sure.
to be reviewing?
Well, you need to look at your declaration of covenants, conditions, and restrictions, or your declaration of condominium, but your declaration. Um, Normally, the declaration will not address the annual meeting, but that's one of those normally. You can never take for granted what your documents do or do not say. So from your checklist, you want to look at your declaration to see if it mentions the annual meeting. Generally, the annual meeting will be covered in the bylaws. In the bylaws of a corporation, you're a nonprofit corporation as an association, provides the mechanics for conducting the business of the corporation, where the declaration are the you shall do's and you shall don'ts. The bylaws tell the corporation how it's to operate. And generally the bylaws will have a provision under meetings, and it means meetings of the members. There's also a provision that's meeting of the directors, but that's not what we're looking at when it comes to annual meetings. We're looking at the meetings of the members. And ordinarily, it will state that the association shall have the annual meeting annually, and then or it will say during the last 2 months of the year, during the week of, you have to look at exactly what your bylaws say as to when the annual meeting is to be conducted. The Georgia Nonprofit Code, which is another law that applies because you are a nonprofit corporation, talks about annual meetings, and it says, except to the extent provided in the bylaws, and then it goes on and says that you shall have an annual meeting. But I can't remember if I've seen in forever a set of bylaws that does not address when you're supposed to have or mandate an annual meeting. So you're looking at your bylaws, generally speaking, and your bylaws are going to say when, sometimes dates, sometimes it's at the discretion of the board, but you have to read your documents, because I can't tell you, because there's no uniform requirement. So that's what you're looking at. And we'll talk about notice and other mechanics in a second, but that's where you're going to find the requirements.
So when we're talking about timing, let's just say the association has just historically had it on November, the second Tuesday of every December. But you're getting ready to plan it this year, and you realize that what the governing documents actually say, or the bylaws say specifically, is that it shall be held on the third Sunday of every November.
Mm-hmm.
Is there a saving grace for that?
Yes, there is. The overall law under the Georgia Nonprofit Code says you're supposed to follow your documents, but if you don't, when you do have your annual meeting, it counts as if you did it correctly.
I love it.
It's a
Thank you.
great law. And it also, the Nonprofit Code also says that the failure to conduct an annual meeting does not affect the validity of actions then taken by the board. So you're supposed to have it annually, and if you don't, when you do have it, it counts as if you did it when you were supposed to.
I love it. That's, I think, one of the reasons why it's so important to understand how all of these documents, which collectively we refer to as the governing documents, but that encompasses the law, the plat, both the Georgia Nonprofit Code, but also the Condo Act and the Property Owners Association Act, if you're an association that is subject to those. They all work together. So looking at just one document is great and can give you the framework for running the association. But realizing that there are other documents that you need to be aware of and in compliance with is crucial. And that's where the association's attorney comes in, because as much as management companies would love to give all of the answers, and some of us just don't know when to stop talking. But
I'm going to share something with you.
Please.
Jim Cranford he's retired, but he was a manager in Myrtle Beach, South Carolina. And he was one of the very first managers in the United States to get the advanced degree that you have, your Professional Community Association Manager's designation from CAI. He wrote lots of things, just a very talented, brilliant guy. And at a national conference, he stood up one time and said, while um, every while every manager can be a lawyer, every lawyer can't be a manager. And I have never forgot him saying while every manager can be a lawyer, every lawyer can't be a manager.
You
To
know,
sort of
there
put it in
there
perspective.
might be a little bit of truth to that, but I think that any manager that really buys into that is probably a manager that's going to lead your association possibly straight into a lawsuit. So I think it's super important as a manager to know when to say we need to
Agreed.
consult legal counsel on this. I can tell you what your documents say. I can tell you maybe what the law says, but
Mhm.
I can't tell you how to interpret how those work together.
Correct.
I can tell you which one has precedent, and I can even tell you maybe what another association's attorney told me on the
Sure.
issue. But if it's
But
not your association attorney giving you that specific advice, you don't want to end up in court with an attorney that would have advised differently, trying to defend a different attorney's
agreed.
interpretation of something.
Sure.
So use your
Yeah.
lawyer.
Okay.
Okay, gonna get off that tangent. The big question, because annual meetings have really, back in the days when I actually managed associations before I took on executive roles, and it's been 10 years, we weren't even contemplating virtual meetings. And certainly when most, well, not most, but a large percentage of the governing documents for the communities were written, it was never even dreamt of that there might be a world in which we were holding virtual annual meetings. So when a community is deciding on what type of meeting they want to have, if they want to have it in person, virtual, or a hybrid version, George, what do they need to know, and what can help them in making that decision?
Well, as you say, it was never contemplated. And with the advent of COVID, the Georgia legislature, through the nonprofit code, has now stated that you can have meetings in person or you can have meetings virtually. So there's a law that now authorizes it. So even if your documents say the annual meeting shall be in person, um, the law now says the board can make the decision on whether or not to do it in person or do it virtually. And when it comes to a virtual meeting, the the law does not go much further than allowing it. So some things that we've gotten into is how do you conduct the meeting? Um, who's the host? Who's the moderator? Who controls what gets said or not said? Is there a question and answer period? And those are things that are not addressed in the code. The code just says you may, if you choose, meaning the board, have a meeting virtually. Um, I will say this from a practical, while you've been enjoying not going to meetings for 10 years,
Oh, I didn't say I don't go to meetings.
um, I, I still have been, and I'll tell you that as an overall anecdotal statement, boards of directors love conducting meetings, annual meetings virtually for the reason that there is more control over the conduct of the meeting that many times doesn't exist when you have individuals who want to make a point. The other thing that we've all seen, and this is true, I guess, with any meetings or participation, you get a lot more participation when it's virtual because people don't have to get in the car or walk to the clubhouse or whatever it is. You can sit back and click on and you're there. So even with the lessening of the COVID infections, I'm still seeing, even for this year, the 2023 annual meetings, many of them are still being conducted virtually. So it's a board's decision.
Right. And well, I'll get into the questions that that all brings up. But what else are we looking to our documents to define for us? I would say the notice requirements.
Yeah,
So
let's
whether
talk about
you're virtual, in person, hybrid, it doesn't matter. What are the where are they going to find the
let's talk
documents?
about the mechanics, the fundamental mechanics of conducting an annual meeting. First, there has to be notice of the annual meeting, and under both the Georgia Property Owners Association Act and under the Georgia Condominium Act, they both state that notice of the annual meeting shall be given 21 days in advance of the meeting, shall be given. Well, does that mean put in the mail on the 21st day, or does that mean receipt? And what we always say to managers or self-managed boards is, why create a potential issue? Get the notice out so that it is absolutely in their hand at least 21 days in advance, as opposed to if you mail it, postmarking that. Don't give people something to argue about. Can you send out notice electronically? Well, the answer to that goes back to overall how you can use electronic notification of members. There's nothing in the law that requires a member of an association to have a computer. There's nothing in the law that requires someone to give
Not
you their
yet.
email address, even if they have a computer. So the issue is this, and I'm going to explain it in reverse. If you have been given email addresses by your members, then you, the board or the management company, you are authorized to use that email address as a means of communication. There's a thing called the Electronic Transmissions Act in Georgia, and it says if you give an email address, then to the person to whom you've given it can use it. But that then leaves the people who don't give you an email address. Well, there you have to use the mail. The other thing to look at, though, in your bylaws, most bylaws have a section on notice, and that will say mail, electronically, hand delivered, and list the acceptable means of giving notice. But however you do it, notice for an annual meeting must be no less than 21 days. The other part of notice is to whom you give notice. It should be everybody, but that then gets into what happens if a person is delinquent in the payment of their assessments. Do they receive notice of the annual meeting? The answer to that is yes. They still are entitled to notice, but the issue then is if whether or not their voting rights have been suspended because they're delinquent. And that's where you have to look at your documents again. Some documents, more modern, meaning in the last 10 plus years, say that if you become delinquent for more than 30 days, your right to vote and your right to be counted in the quorum calculation is automatically suspended. Other documents say that the board of directors may suspend your voting rights and calculation for quorum if you're delinquent. So you need to know whether it's an automatic after 30 days or whether the board has to actually take action to say the following person, because they're more than 30 days delinquent, are ineligible. Eligibility is a critical thing when it comes to a quorum. The quorum is the minimum number of persons, members, that must be in attendance in person, by proxy, And when I say in person, that includes electronically. If you're doing it electronically, that counts as being in person. But it's a minimum number for participation. The Georgia Condominium Act and the POAA state that unless the bylaws provide otherwise, a quorum is 1/3 of the eligible persons. So that gets back to eligibility. You got to make sure if you can suspend, if it's automatic or it takes action. And if you do not have a right to vote and you can't be counted in the quorum, then obviously the number that need to be in attendance to have a quorum goes down. So eligibility, look at your documents. We've had some real fights over the years where a board was supposed to take action. Older documents say the board may suspend, and they didn't do it. And then someone shows up at the meeting, and the person at the check-in table says, I can't give you a ballot, and I can't count you towards a quorum because you're delinquent. And the person says, well, that's news to me. Who said I can't vote? And then we get into, if you didn't take action, then we cannot suspend the vote. So it's critical that you know your documents on the minimum number of persons that have to be in attendance and how you calculate that number.
Right. And George, can you, I have always, and I've been in this business not quite as long as you have, but
be careful how you say that.
well, you said how long you've been in the business, and I'm just saying that I was
no,
a wee
I'm
one.
kidding. Obviously, I'm kidding with you.
Okay, I've been in the business for 25 years, so it has been always my practice for every annual meeting where a delinquent owner's right to count towards a quorum or to vote is written into the documents. On my annual meeting notice, I will say, if you are, and I'll take the verbiage straight from the documents, if you are shown on management's records to be more than 30 days delinquent to any payment owed to the association,
right,
you are not eligible to be counted towards a quorum nor to vote.
exactly.
And there's your
It
notice.
avoids it. Mm-hmm.
There's your notice.
That's right. Okay,
Everybody
that
now
always
goes into
raises.
their portal and sees if there's. Now, I always encourage my managers to reach out to the boards because you've always got that one homeowner or that handful of homeowners that have a random 34-cent balance or
Yeah,
a $5 balance that's been
right.
sitting out there for years. Nobody knows where it came from or why it's there. You don't even bother to waste the paper to send them late notices about it. Are you going
Sure.
to really restrict somebody's right to vote over something you're that unconcerned with? Set a threshold. And it's usually, I mean, I've had associations do $100. I've had them do $50 if their assessments and late fees and such are lower. I've had some say $10. Anybody that owes us more than $10. So
Yeah,
that's a board call, but I do encourage you to use some common sense. If you actually want to hold a meeting where business can be conducted and you want people to actually vote, if you really don't want to ever reach a quorum and you don't want to have any legal votes, then by all means, 50 cents, you're out.
yeah. Common sense. Can we exercise that anymore? uh, well, I'll throw one
That
out at you.
depends.
Yeah. What if someone comes to the annual meeting and management shows them on their ledger that they owe, let's just make it up, $500. Let's just make up a number. And the person says, okay, and they write a check for $500. Do you count them? Do you give them a ballot? What are your thoughts?
So that's an excellent, I'm glad you brought that up because that happened to me one time.
Yeah.
Actually, even funnier than the time it happened to me was the time it happened to one of my bosses, who we managed his association. He did, he took no active role in the governance of the association, but he attended the annual meeting uh, as a good homeowner. And he was standing talking to someone, and a gentleman approached him and handed him, I think it was 19 cents in coins, and said, "Can you please go tell them I've just satisfied my balance?"
Yeah,
I mean, what do
yeah,
you do? But I have had people try to hand me cash at an annual meeting or try to hand me checks. I'm trying to help with the sign in. So, also, it's very helpful if on your notice after that little blurb about not being eligible to vote, that the cutoff, there should always be a cutoff for when
yeah,
those delinquent balances are counted. So anyone with a balance more than 30 days showing on the the management company's books and records as of 4 p.m. on December 2nd will be
right.
ineligible to vote. Funds may not be, will not be accepted at the annual meeting.
Correct. And in fact, there's a technical term for what you just described. It's called the record date. And the Georgia Nonprofit Code says that a board, an association, is supposed to set the record date. And the record date is exactly what you just said. You state that in order to be eligible to vote, whatever, you must be current as of whatever date you just said. So it doesn't matter if they, as you 402, they give you a check. Sorry, the record date was already set. And you have to abide by that. But yeah, that's the way to approach it. And again, the law requires us to set a record date for the very reasons that we're discussing.
Right. Excellent. So another important thing as you're preparing your notice and your agenda is going to be the requirements for each item on your agenda.
Mhm.
Remembering that your annual meeting is a corporate business meeting, not a community
Social?
social. Okay, we'll go with that.
Yeah.
It's not that for the airing of grievances. I love this story. My favorite annual meeting in all of my 25 years. I had managed this association a couple of years. They had this new board president who took no bunk. She was all business. She was in the corporate world. She was an executive. She knew her stuff. Required to have the meeting on the fourth Sunday of every January. So we all trudge out to this Sunday annual meeting, which, by the way, most management companies don't do Sunday meetings anymore at all, and Saturdays will cost extra. Um, but trudge out. We get in at exactly the start time of the meeting. She says, "Drop that sign in pen. The meeting is now called to order. Do we have a quorum?" And somebody says, "Wait, I haven't signed in yet." She said, "It doesn't matter. We're called to order." Yeah, a little over the top, but there was really no business to conduct. So, which she knew. So she says, "Anyway, here's the state of the financials, and here's the budget for the upcoming year. There's no old business from last year to vote on. Is there any new business from anybody in the room?" Poor gentleman stands up and he says, "Yes," and he goes kind of roundabout to get to the fact that teenagers in the neighborhood are using his yard as a cut through to a neighboring business. And she says, "This is a corporate meeting. That is a personal problem."
Yeah, I can hear it.
There. Now, I don't recommend dealing with your neighbors in such a way. But the point that she was making had some validity that, address that, with the manager. The manager is going to tell you it's a trespassing issue, call the police. There's not much the association can do, but don't cut people off at the knees necessarily like that. And that's not why I said it was my favorite annual meeting, but because it was adjourned exactly 12 minutes after it was called to order.
Yeah.
12 minutes.
Well, let's stay with that. They didn't have a quorum, apparently.
Right.
All right. So if you don't have a quorum, you cannot call a meeting to order. Under Robert's
Correct.
rules, the only thing that you can do, if you so choose to, is to set a time and place to reconvene or attempt to convene the meeting. Well, what comes out of that, as you know, is those people who are there, again, in person, whether in the room or on a video screen, they're there to hear and conduct business. And what you just explained is, if you don't have a quorum, you cannot conduct business. You said there was nothing to do. Well, if you don't have a quorum, you didn't have an annual meeting. And I'll talk about that after this next comment. Many times, if you don't have a quorum, the board will go ahead like that person did, but maybe in more detail, and go over their reports and information for those people who did attend. But from the standpoint, did you have an annual meeting? There's a split of authority with, yeah, we did, we just couldn't call it to order. And I'm not being facetious. Or no, you didn't, because you couldn't call it to order.
Right.
And so that then leads into, and why don't we jump ahead to board elections, because it fits right in here. All right, so you need to elect members to the board, and you don't have a quorum, so you can't call the meeting to order. That is something that is happening in every association. We can't get a quorum, and we need people on the board. How do we handle that? And this is where I'm not giving specific legal advice to anybody. I'm just giving you the overview. The Georgia Nonprofit Code says that a person elected to the board serves until their successor is elected and seated. Saying it beyond that, it says that a person remains on the board until their successor is elected or seated, with this one addition, unless you resign. So you go to the annual meeting, you don't have a quorum, you have people who are on the board of directors, you can't elect anybody new. Well, those people who are on the board, even if their term is expired, they continue to be on the board unless, again, they resign. They send in a formal resignation. Well, let's say a person whose term is up says, I resign. I don't want to be continuing on. Well, then the next question is, does that person replacement have to be elected, which was the intent of having an annual meeting and elections, or can the board fill the vacancy? Well, we're now going to be practical. You have to look at your bylaws to see if the board has the right to fill vacancies on the board. And I can tell you as a sort of just a common practice is many boards of directors will not attempt to have another annual meeting because they tried, and they will fill vacancies by appointing someone to fill the slot that should have been elected. You have to look at your documents, have to look at vacancies, but that seems to be the rule of thumb. We tried, hey, are you willing to serve on the board? Great, you're appointed. But we have to look at it. But that's the practical way that boards, and this is nationwide also. Can't get quorums, we've got to have a board, and that's what they do.
Yeah. And this is making me want to go down a whole nother path that kind of takes us away from annual meetings, but I think that it's so relevant to so many associations, um, where you cannot get a quorum to elect a new board because people don't seem to care or they just aren't making the time, whatever the reason is. The same board has been in place for years and years, and they are tired of it. They don't want to do it anymore. And they say to their manager or to their attorney, and they're the last two people standing, say,
Yep.
I'm just going to quit. Nobody will fill the vacant positions. I'm just going to quit. I know what I usually say to them, and I should probably be referring them to you, but usually at this point, they are like ready to hand me a resignation.
Yep.
And I feel like I need to give them a little bit more than your phone number.
Okay. So what do you say?
So I explain that when a corporation does not have a board of directors, to make its decisions for it, that the courts will put it into receivership and hire an attorney to serve as their receiver, making board decisions. And everybody's association fees are going to go up to pay this attorney to do what the board doesn't want to do. So
Absolutely.
either get out there and find somebody to take the places or suck it up and stay on the board because you do not want to go into receivership.
No, 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 you do not. And you're exactly right. Um, there's a story, it's been brewing for a while, but there's an association in Florida where the board of directors, various people on the board conspired and stole conservatively over $2 million. It's just beyond belief what they got away with. Setting up dummy accounts, paying people to not show up at work, just lots of things. And they appointed a receiver. And the receiver is spending about $200,000 a month right now because of auditing and financials and running the corporation. And you've got people, I read it today, saying, this is crazy. He's going to put us into bankruptcy. We're going to be worse off than when the people stole from us. So that's an extreme. I know that. But yeah, you go into receivership. The attorney general will appoint a receiver and they will run the corporation. I've seen that once, and that was probably 35 years ago.
Right. I've usually once it's explained to the remaining board members what's going to happen, they either opt to stay on the board or they get very persistent with their neighbors and get somebody else to step up.
Sure.
We've also I had one board get really, really creative with getting a quorum at their annual meeting. I don't recommend this, by the way. It was very dramatic. But they sent out with their notice the next year's budget with like a 300%
Yep.
increase in
Yep.
assessments, and everybody showed up. They hadn't had a quorum in like 10 years. Everybody showed up ready to fight. And
Yep.
as people were signing in and riling each other up for this fight, me, the manager, and the board are standing there smiling, saying, hey, so sorry. We
Never
actually did
mind.
a new budget
Never
revision, and
mind.
here's the actual budget.
Right.
Glad you're here. We have a very important election tonight, so take a seat. People weren't happy, but the board explained, look, we can't get you guys here and we're done with this. We've been serving on this board for 10 years since the last election.
Sure.
Somebody's got to step up. So it actually ended up, it worked, but I
Well, what and
think
why
there are
don't we
other ways
stay
to do it.
with the issue of the budget at the annual meeting? Um,
Yes, please.
One of the things that I want to address here is, first of all, when it comes to the budget, you've got to look at your documents. And most times this is found in the Declaration of Covenants or your Declaration of Condominium, where it says the board of directors shall, and then this is where it can vary, shall no less than 60 days before the annual meeting prepare a budget, and shall no less than 30 days before the annual meeting send the budget out, or some words to that effect. But there's a time frame that most documents require action on next year's budget. Then the thing that people don't follow because it's so anti-American. In America, we're used to voting for or against something. Well, I'm going to go way back in my career when the documents used to say that the budget had to be approved at the annual meeting. Sometimes it said just by a majority there, or sometimes it said by a majority of the entire membership. Now think about that. The budget hasn't gone up. We're back to, why would I go to the annual meeting when the budget hasn't gone up? Well, it wasn't approved. So a long, long time ago, we came up with the reverse. Most documents, virtually everyone's in the last 20 plus years, say that the board shall present the budget, and then it says the budget is automatically approved unless disapproved at the annual meeting. Okay, go ahead.
So tell me, George, does this mean that the board should call for a vote to disapprove the budget that they're presenting?
Absolutely not. And if I'll address that first. It's automatically approved unless disapproved. It's up to a member or members to make a motion to disapprove. And then most documents say that that motion has to be approved by a majority of the entire membership. And we did that on purpose, because think about it this way. There's nothing really wrong with the budget. It's gone up a little bit, but most people say, okay, that's inflation, no big deal. But you have a group that comes who want to defeat it. And if a budget could be defeated by just a vote of a majority who vote, then you'd have budgets disapproved every year, theoretically. So it's a majority of the entire membership. But no, the board should not say, after presenting the budget, does anyone want to make a motion to disapprove the budget? That's not your role, not the board's role. It's up to someone to do that. And I've had people after a meeting come up to me and or the board and the manager saying, that was really deceitful. Okay, what was deceitful? Yeah. You didn't state that we could make a motion to disapprove. And the answer to that is it's spelled out in the documents. You're charged, assume that you've read the documents. The other thing, though, sometimes people will make a motion to approve with that language, though, that says it's only to disapprove. And so many times the board will say, okay, all those in favor of the budget. And with few exceptions, it gets approved. But here's the problem. What if they don't approve it?
Right.
And you didn't ask for a motion to disapprove according to the documents. So as much as you want to give people the ability to vote to approve something, don't. Make sure, but I bet most everybody's documents say it's automatically approved unless disapproved. What happens if it's disapproved? I'm glad you asked that question. Most documents say that last year's budget remains in effect until such time as the board presents another budget that's not defeated. So we're stuck with last year's budget. And if you really have an increase in insurance, does anybody have that happening, by the way? That's another topic.
Everybody.
Yeah.
Everybody.
And you need the money. So then the board would have to come back with another budget and present it, and hopefully it wouldn't be defeated.
Right. I don't think I have ever seen a budget where the bylaw, or I'm sorry, the covenants, the declaration calls for it to be approved unless disapproved by a majority of the membership. Very rarely do we even have that many present at a meeting for if somebody were to
Make the
make the
motion. Yep.
motion. Usually, I've had it maybe a handful of times where somebody makes the motion, and I usually just advise the board, acknowledge the motion, but please point out that there's not enough people in this room to pass the motion.
I
Is
gotta,
that not?
I
Oh,
don't
see?
agree. I don't agree. And
Okay.
here's why. The motion is in order
All
and it's
right. So go
seconded.
ahead and take the vote.
Okay. And even though we know the results, because there's not a majority of the entire membership there, you still have to honor the motion in the second to take
Okay.
the action. Again, we know what outcome is, but we can't say because there's not enough people here, we won't even vote on it. It makes sense.
See why I have an attorney do these with me? Because I get in trouble.
Now, let's say you did that and somebody then challenges it.
Mhm.
Well, Judge, Your Honor, they're spending a lot of money to go down here, and the bottom line is it wouldn't have passed. And if you're saying we have to go back and vote on it, then okay. But if they make the motion and it's seconded, you got to vote on it.
Okay.
Okay?
Yep. And then it's just motion defeated. There
Motion,
aren't
yeah,
enough, there aren't enough votes to
correct.
disapprove.
You're going to move on with the meeting and then announce the results.
And minutes, meeting minutes. This is something that is kind of, and it's not a hot button. It's just something that I think there's a lot of misunderstanding about.
Mhm.
So meeting minutes are generally approved at the next meeting of the same type.
Mhm.
So at each board meeting, you're going to be approving the minutes from the meeting before. At each annual meeting, you'll be approving the minutes for the meeting before. Now, I've walked into annual meetings and they hand out minutes from the previous year, and they say, hey, everybody has a copy of the minutes. Is there a motion to approve? And I say, you didn't have a quorum last year. How do you have minutes?
Excellent. Yep. Yes.
And they say, yeah, but we've never had a quorum, or we haven't had a quorum in 10 years. And so we just go ahead and do it so that
Right.
the people that are here feel better. If you want to keep notes of what's discussed at the meeting, please not in great detail, please not a transcript, but if you just want to make a note, quorum wasn't met, however the board presented the budget, there was
Exactly.
discussion from the floor. If you want to go through that exercise, feel free to do so. Just don't call them minutes, because they're not. Minutes are corporate records, and this sounds like something that should be coming from you.
No, you got it. You got it.
um,
And also go to the name. I can't take credit for this. An attorney in Washington said this, and I use it all the time. They're called minutes, not hours, days, weeks, months, or years. And
yes.
so they're not a transcript. They are minutes. They are capturing what happened. So rather than saying it was called to order, the first item on the agenda was to elect the board of directors. You're not going to say, and then Shelby, who's running for a seat, said the following as to why she's qualified to be on the board of directors. The minutes would say, each candidate was given the opportunity to explain their credentials. After that, a motion was made to close nominations and a vote was taken. That's it. And then you would say and the following are the results, as opposed to all of this other information. Because again, they're minutes, not anything beyond that.
Right. Okay, so you and I are both chatty, so I'm gonna kind of jump ahead. Sorry, because we're gonna run out of time.
Nah,
Uh,
we're going to cover everything. We are.
yes. So I want to touch on virtual meetings.
Mhm.
If you're holding either a virtual or a hybrid, I happen to think hybrid makes the whole process of certifying a quorum and taking votes a bit easier than
Mhm.
a strictly virtual. So virtual gets more attendance, but is it practical and possible to certify a quorum and take votes at a virtual meeting?
And that goes back to how you have people sign in, how you acknowledge or how you confirm that people are members and you don't have more than one per unit, that type of thing. So it's a matter of, and I am not a computer person. I'm not any of those things. So I don't know how to explain it, but there is a way of confirming who is whom. Um,
Yes.
I've seen boards say, or managers and notices, if you have not given us your email address, please give it to us so we can use that to confirm when you log in, or some words to that effect. But yeah, I mean, I see that. And voting, I mean, it's the raise your hand if that's how you do it, or if another way of acknowledging the vote. But generally, I see just the raise the hands.
Mhm.
Now, the other thing that goes to what you're asking is the election of directors. And that goes to what so many boards are doing is this. Rather than electing the directors at the annual meeting, again, this really depends on your bylaws. So I'm giving you just an overview. Many associations are sending out the names of nominees prior to the annual meeting with a ballot. And the ballot has the folks that have agreed to have their names in nomination, and then it has lines for people to add their own nominations. And the ballot goes out and it says it must be returned by whatever the date and time is that you set. And then at the annual meeting, you announce the results. And even if you don't have a quorum, you can still announce the results because it was not dependent on a meeting. It's over. So it's called a ballot in lieu of a meeting.
Right. So as long as you got enough ballots to satisfy the bylaw requirements for that vote, you
Correct.
can
And
do
what
that.
that
So
says, go ahead.
right. So I've seen it done that way. I've also seen it done where at the virtual meeting they say, "Hey, it's there are too
Yep.
many of you to possibly certify a quorum or try to take votes. So we're going to go through the agenda, hit all those items. We're going to let the nominees introduce themselves. We're going to take nominations from the floor, and then we're going to send out ballots after. You'll have 5 days to return them, and then the
Okay.
new board of directors will be elected."
I'm
That's
seeing more of
also
that.
been
And the reason for that is what you said. Pre-COVID, this was standard. Nominations and nominations may be made from the floor. Well, post-COVID and virtual meetings, bylaws have changed, are changing to not specifically mention nominations taken from the floor. Because you're right. If your set of bylaws say that nominations must be taken from the floor, then what you just described is what you have to do. You have to have the meeting, take your nominations from the floor, and then after the meeting, as you explained, send out the ballot. Now, just very quickly, the ballot is authorized under the nonprofit code, but it's not just ballot. It's a very specific ballot that says that you have to send it out to everybody, that you can send it by mail or you can send it electronically. It must set forth each proposed action. So let's say we're just voting on directors. Well, as of July 1st, there's a new wrinkle. It says that when it comes to electing directors, you have to provide for a vote for each person or withhold a vote for each person, which I'm not sure why the legislature did that. So you check for George Nowack, but you now have the option of checking, I withhold a vote for George Nowack. I mean, it's as if you didn't vote for me, right? But it's
Right.
now the law. And then, as you said, it has to state the date and time by which it must be received in order to be counted. So it's not just this little thing that says ballot, it's this more detailed thing.
Right. And that is why it's really important. And you will often, a lot of boards email their manager, hey, we want to have our meeting on this date. Please prepare notice. And then the manager will come back, or person by virtual. Do you want to do proxies? Do we want to prepare ballots in advance? And this is where a lot of times the manager will say, shall we have your attorney prepare the meeting notice and accompanying documents?
Mm-hmm.
Now, a standard notice and proxy form, even
No.
George is saying, don't pay your attorney to do that. It's
What?
pretty
There's a
standard.
house going to fall on me, but go ahead.
It's pretty standard, and your management company should have a standard template that they then customize to work with your association's documents, and they should work together with the board to prepare that. So when they send you back a draft, please look at it. Keep in mind that unless you have a dedicated on-site manager, your manager has a portfolio and is probably preparing 10 or so different annual meeting notices, maybe not at the exact same time, but in a pretty short period. It's not common to use the same and then just save as, change little details and miss a detail. So
Yes.
do look at what your manager is giving you as drafts. But when it comes to the ballot, especially with the recent law changes, it doesn't hurt to at least just shoot the draft over to your attorney and say, hey, are we in compliance with our documents and the law?
Exactly. And what comes out of all of what you just said is the manager is acting as the agent, but the buck stops with the board of directors. You're doing your best, but bottom line, if there's an issue, it's the board that has the responsibility. And what I see so many times at annual meetings is the board expects the manager to do everything. That the board wants the manager to run the meeting. The board wants this. And while that can be done, I'll say from my perspective is, well, if you're the president, why are you having the manager run the meeting? Why is the manager doing all of the talking? So one of the things that we need to understand is the role of the president, the secretary, the treasurer, committee chairs, and the manager. Well, my preference is the president should be running the meeting. Opening remarks, reports of the president. Then you have your committee members or your other officers deliver their reports. Not sometimes the board for the budget will say, I'm going to defer, or will the manager please present the budget? I don't have a problem with that, but it shouldn't be the manager doing everything. The committee chairs. In the perfect world, there's committees.
It depends.
And they give their reports. And the manager is really there to provide the backup as necessary, or when it comes to the budget, many times the manager will present it. But the whole purpose of the annual meeting, according to the law, is to present comprehensive reports on the affairs of the association for the previous year. That's the technical thing. And it's my one time a year to see who the president is and who the secretary is and who the treasurer is. So it's important that boards don't go into an annual meeting thinking the manager is going to do everything, because that's not the role of the manager. I mean, I've been to those meetings, and I'm sure you have too, is, well, why aren't you saying anything? Why is the manager answering all these questions? And it gets contentious then.
Yeah.
And,
I early in my career, I guess the associations that were in my portfolio were all just used to having the manager run the meeting, because I really thought early in my career that it was my job to run all of these annual meetings. And the first time a board said to me, so you're going to help with sign in, and then you're just going to stay for the meeting in case anybody has any questions that we need your help with, right?
yep.
I was like,
Whoa.
hold
Yeah.
on. So I went to my boss and I said, wait a minute. This board president is acting like I'm just, there to like give support. And he's like, that's what have you been doing? And I'm like, running every annual meeting.
What do you mean the president is acting the president?
I know. What do you mean, indeed? Now, I've had treasurers, and actually, I've had presidents who, in all of the preparation for the annual meeting, because now I have this conversation with my boards. So you're prepared to give a president's report, and you're prepared to go through the end of year financials and the upcoming budget, and you're prepared to do this. I make sure it's clear that who's doing what. But I have had one that everybody was good to go. And then as we go walking into the meeting room, one of the officers will look at me and say, I can't do it.
I can't do it.
I can't
Yeah.
do it. I hate public speaking. I can't do it. Can you do my report?
Mhm.
I really wish you would have told me that yesterday so I could have read your report and reviewed your financials and spoken from a better place. But most managers can get through it depending on
Sure.
what it is. But really, if you need your manager to give that type of support, it's just really important to let them know that expectation coming into the meeting.
Agreed. Let's do one other thing when it comes to elections.
Boards, officers, directors, please.
Yes. Um, to no one's surprise, sometimes people don't like the results of an election.
Oh, that too.
Okay. And someone will say, um, uh, I object, or I want to recount, or words to that effect. Or they wait a week or so and then they send a letter saying, I don't believe the results are accurate. Well, in order to force a recount, a motion for a recount has to be made before the meeting is adjourned. So if you wait until the meeting's adjourned, you can't do it. Well, what about when we're conducting the ballot after the meeting and someone objects? Well, there's no case on this yet, but logic says this: you have a reasonable amount of time after you get the results to ask for a recount. Does the person who asked for the recount have the right to be in the room? No. It's up to the board to decide who is going to do the recount. When it comes to the counting, if you have a contentious election, my advice is you ask for volunteers from the audience, including some of the people who don't want the current board in, for them to count the ballots with other people.
Yes.
Let me say this: it's not the role of the manager to count the ballots. And I got to say this from personal experience: it is not the role of an attorney to sit in. And here's the reason. And this happened to me. I was in the counting room, and after it was over, there was a challenge. Well, I couldn't be the attorney because I was also a witness. So from that day forward, none of the attorneys in my firm participate in counting. So that's the other thing that comes up in these things is if there's a challenge, it's got to be, if it's at an annual meeting, you have to make it before the meeting is adjourned. And like I say, if it's virtual or ballots afterwards, it's going to be a reasonable time.
Awesome. I know we've gone over. I've got one more thing that's going to be super quick before we go. Thanks, guys, for hanging in with us, by the
Yes,
way.
thank you.
A lot of boards and a lot of homeowners think that at an annual meeting, they are electing the officers. In 25 years of reading documents, I have seen one set of bylaws where the homeowners are voting for the president, the secretary, the treasurer, the vice president, etc. Only once. In every other set of documents, for the hundreds and hundreds of community associations, the bylaws have said at the annual meeting, election of the directors will be held within usually 10 days. The directors newly elected are then required to have an organizational meeting at which time the directors elect the officers.
Correct.
So even if you're having an election, you've got a 5-person board, 3 people are staying on, only 2 positions are being elected. Those officer roles, even if you've got 3-year terms, say, for every director, the officer terms are 1 year, unless stated otherwise in your bylaws.
Correct.
So you elect 2 new directors, and then the 5 of you get together within 10 days of that annual meeting and you elect who the officers are going to be for the coming year. I see it all the time. The boards talking to homeowners about who's going to be elected president, who I'm going to elect president, and I'm going to elect this guy to treasurer.
Nope.
That's for the directors to decide. Homeowners will elect directors, directors elect officers.
And all of this goes back to before the annual meeting, the directors need to read your bylaws. Have a working familiarity with the bylaws, and then having prepared in advance, if it raises any questions, you have the time to ask them. But know your bylaws.
Yeah, and also this is just like a pro tip. The way I always 10 days can be a really tight window, especially if you're holding your annual meeting in the wintertime around the holidays. People are traveling,
Yep.
schedules aren't aligning. In order to avoid running afoul and having your old board sitting there waiting for you guys to officially take place,
Yep.
have everybody who was just all of the directors stay behind at the annual meeting. You walk over into a corner, you convene the organizational meeting of the
Yep.
new board of directors, you elect your officers, you adjourn that meeting, and you go home and you have satisfied your requirement for the organizational meeting. And everybody
Exactly.
can go about their holidays and then start having your
Right.
monthly meetings thereafter.
Agreed. Yes.
So I don't see any questions posed in the question box. So and we're 10 minutes over. George, thank you for hanging in with me. Attendees all, thank you
Thank
so much
you.
for hanging in.
And
This
thanks for
was
everybody
fun,
else.
as I knew it was going to be.
Yeah.
I think you and I can talk
Talk
HOA
forever.
forever. I could go on all night, but I won't. My dog is getting mad. He's like, dinner.
Well, again, I thank you very much for inviting me. This was very, very enjoyable. And anytime you want to pick it up again, I'll be glad to do it with you. It was a lot of fun.
I had a
Thank you.
lot of fun too, and I will definitely be calling on you again,
Okay.
George.